Now turn to the second case on this morning's docket. That is case number 103334, Kenneth W. Sloop, Jr., the Kansas Department of Revenue.
May it please the Court. Kevin Shepard appears on behalf of Kenneth W. Sloop, Jr. I'm asking for 3 minutes of rebuttal time.
3 minutes is granted.
Thank you. The primary purpose of this appeal is to ask this Court for a ruling that there was no probable cause at the time of Mr. Sloop's arrest. That question was not answered by the District Court, and it was not answered by the Kansas Court of Appeals. It's implied. It's not in black and white. It appears that District Court and the Kansas Court of Appeals agrees that there was no probable cause at the time of arrest. It gathers its reasonable grounds from what occurred later after Mr. Sloop was handcuffed and taken down to the police station for further investigation.
Can we back up just a little bit even from that? What about the stop of the vehicle?
The tag
Was there a
light?
reasonable suspicion to stop the vehicle that kind of started the entire process?
Yeah, the tag light.
Observe. I think was not driving in an upright manner or too upright, which caused some curiosity on the officer's part, which led the officer to follow the vehicle, didn't observe any traffic infractions, but noticed an improperly illuminated tag. Is that right?
That's correct.
Is that reasonable suspicion to believe, to stop the vehicle, to start this process?
You really threw me for a loop, because I did not expect to answer that question.
Well, isn't that partly what Martin's all about?
It is. And Martin is an important case. And I'm glad you asked that question, because the fact is that there is a statute in Kansas that says that you have to have a properly illuminated tag light. And because it's a traffic violation, and the case law that goes throughout Kansas is that if you have a valid traffic stop, you can pull them over. And under the Wren case, we're not really supposed to question the motives. However, here, it should be taken into account under the reasonable grounds analysis. And the fact that this Officer Bergerhofer, decided to follow Mr. Sloop's vehicle, mainly because he was slouched back he was not slouched back, he was at his steering wheel, and that drew his attention, and that he kind of stopped and started, but he didn't commit a traffic violation in making his turn. That really is questionable grounds as to what his intentions were. And his intentions are important, because here, this officer gave Mr. Sloop a PBT and arrested him exclusively on a PBT that was administered improperly. And he admitted it. And I direct the court to review the transcripts, pages 15 through 17, and specifically page 17. I asked Officer Bergerhofer at trial before the district court, did he arrest Mr. Sloop so he can continue his investigation? And he said yes. It wasn't complete. And that's Wonderly. And Wonderly applies. And Kansas Court of Appeals dismissed Wonderly because it's a criminal case. However, this court in Allen applied Wonderly. It rejected it on its facts, but this court did not hold that Wonderly is inapplicable in a Kansas driver's license proceeding. Because what the court held in Allen, 292 Kansas 653, 2011 case, was that the probable cause standards equate to reasonable grounds. There is no differential standard because one's a criminal case and the other is a driver's license suspension proceeding. Reasonable grounds, the standard, is the same as probable cause. And probable cause is required. And it is under statute. KSA 8-1001, Section B, requires that there be reasonable grounds and an arrest for an alcohol-related offense.
Or otherwise in custody.
Or otherwise in custody. And I'm sure the Kansas legislature intended that to be validly placed in custody. It was not going to endorse an illegal arrest. We have that in our statutes under KSH 22-2402. You got to have probable cause to make an arrest. And if you don't, and he's handcuffed to do further investigation, then the statute, not so much the constitutional basis, but the statutory basis, bars a state from making it for furthering a suspension proceeding because here there was not a valid arrest.
We had an argument yesterday that on the civil side, you can take someone into custody and handcuff them and take them down to the station, and as long as you're investigating the DUI, that's okay. And from the civil side, and basically Martin says, well, whether it's okay or not, it doesn't matter. You can't do anything about it.
We're referring
So,
to, I'm sorry.
So how do we, how do you get relief?
Are we referring to the Schrader case?
Yes.
Yeah.
Okay, well, my understanding was, and Justice Moritz, when you were Court of Appeals, ruled that you had to have a valid arrest. And if you were driving on a suspended license, that's not an alcohol-related offense. So you do need an arrest under the statute. And that's what I'm wondering here, asking the court, are we going to strictly comply with the statute like this court did in Martin, like this court did in Brook? Or if we are just going to liberally construe the statute when it's in favor of the department? And I asked the court to really look at that liberal construction provision because it's supposed to protect the public. And shouldn't the public be protected from illegal arrests? Isn't that a valid purpose? Because it is. And here there wasn't one. There was no valid arrest for anything, not driving while suspended, not anything. An improperly administered PBT.
But when we're looking at it strictly from the civil side, aren't we more akin to an administrative search?
No.
Why not?
Because, again, if we're looking at it from the civil side, then we look at the statutes. And the statute clearly requires that there be an arrest. An arrest for an alcohol-related or otherwise taken into custody. But for an alcohol-related offense, for an operational of a vehicle, alcohol-related offense. And if that is a statutory standard, and that is the requirement, then we have to follow it. Yes.
Counsel, in looking at this as a continuum of evidence, starting with the officer's first observation of your client, how far down that continuum do you say that we should draw the line and say anything after that, this particular event, cannot be considered to determine whether your client should have his license suspended?
The same standard that we look at when we...
I'm not talking about the standard. I'm saying what event.
what event here?
What point on that timeline do you say anything after this cannot be considered as
Handcuffs.
evidence?
Handcuffs placed on Mr. Sloop.
So anything that happened before that could be considered by any court determining whether this was reasonable grounds or probable cause or valid arrest or whatever you may want to call it?
Correct. Okay. And if we go so far as to, and if we extend to Justice Rosen's questions about whether or not it was reasonable for him to even stop him in the first place, that should be considered as well.
Well, I'm still trying to figure out at what point are you saying any evidence afterward cannot be considered as a matter of law.
As soon as he was placed in handcuffs. And what I asked this court in reviewing all that is to look through the lens of what's required under the statute, and the statute specifically states that you have to be under the influence of alcohol, and under the influence is not just evidence of consumption. All we had here was Mr. Sloop admitted to drinking one beer. No evidence to suggest anything else, and the smell of alcohol. And while that may give him some reasonable suspicion to start an investigation, his investigation wasn't complete, even using the words by Officer Bergerhofer himself. It wasn't complete. Consumption doesn't equal impairment. Where the statute provides for the department to suspend somebody's driver's license and take that away from them is that you have to have some sort of evidence that they were under the influence. And under the influence, the smell of the odor of alcohol doesn't get you there, and an admitted consumption of one beer doesn't get you there. You have to have more facts to show impairment. Again, I asked the court to make that finding, and based on with your question, at the time of the arrest, at the time when Mr. Sloop was put into handcuffs, that there was no probable cause, and that I asked the court to answer that question, because at that point in time, the statute, Wonderly, and I understand what this court said in Martin, but the Constitution requires that no other evidence be considered. They have to have it at the time of the arrest. We've even had that in case law, in the Sullivan case, at the time of the arrest, and that's what it should mean. And the district courts should not be confused about when that time is supposed to start, when they're placed into custody. I see I have about 25 seconds. Is there any other questions?
Have any questions of counsel? Thank you, counsel.
Thank you.
I'm James G. Keller, appearing for the Kansas Department of Revenue. I think there are two, maybe three issues in this case. Whether there were reasonable grounds, which was the only issue that was really raised before the district court. In the district court, plaintiff put on a DVD of the field sobriety tests that were done after the arrest, and then after putting on that evidence, argued in closing that the court shouldn't consider it, and made arguments that the court should be limited to what happened prior to the arrest.
In that regard, looking at 81001 subsection B, it speaks to the person's been arrested or otherwise taken into custody for any offense involving operation of the vehicle under the influence. To me, that reads that regardless of whether the person is arrested or simply taken into custody, it has to be for the criminal offense rather than for investigatory purposes. How do you answer that? It doesn't say taken into custody for further investigation of the crime of driving under the influence. It says for any offense involving driving, alcohol-related driving offense. You understand what I'm asking?
I think so.
Because we had some argument yesterday that it's permissible to take someone into custody to further the investigation. And so how does would that dovetail into the plain language?
Well, I think this case is different than Schrader. Schrader dealt with an issue about whether...
Well, What I'm talking about is whether the otherwise in custody has to relate to the criminal offense rather than further investigation. And to me, that is the issue here.
Well, I think that's true. I think our position, though, is that the reasonable grounds. I mean, in this case, he was obviously taken into custody. The officer put handcuffs on him at the scene, and the reason he did it was because he believed he was operating under the influence. Now, the part of the issue that you're sort of raising here, to me, relates to a problem that I've always had with the excuse me, the City of Norton versus Wonderly case. In that case, the Court of Appeals looked at they set out that it was an objective standard that was supposed to be applied. But then when they got to the analysis of the evidence in the case, there's twice in that case that they talk about what the officer thought, that the officer didn't think he had enough, that sort of thing. In this case, our argument is that the officer had enough to arrest at the time that he put him in handcuffs. He had reasonable grounds at that time. Now, as far as the reasonable grounds analysis in 810.01b, their argument is that has to exist at the time of arrest. We would disagree with that. The language of the statute, 810.01b, says the officer shall request a person to submit to testing if the officer has reasonable grounds. In other words, he has those grounds when he makes that request. Now, those grounds may have developed over some period of time. And then it goes on to say, and one of the following conditions exists. In other words, the condition exists at that time. The first of those is that the person has been arrested or otherwise taken into custody. In other words, that has already occurred.
But isn't that circular? I mean, you're using the arrest to justify the reasonable grounds, and the reasonable grounds to justify the arrest?
Not at all. I'm not using it to justify it. What I'm saying is the statute requires there be reasonable grounds, independently from
To request testing.
Right.
But we also require probable cause or reasonable grounds to arrest.
No, I'm not saying that. What the statute states is that the person has been arrested or otherwise...
I know what the statute says, but constitutionally we require probable cause or reasonable grounds to arrest too, don't we?
Yes, in a criminal case, there has to be probable cause to arrest.
Can we arrest somebody or without probable cause for a civil purpose?
Well, because these things are so entwined...
That's a yes or no, though. I mean, do you think that's constitutionally permissible?
What it gets to, I think, probably is what is the outcome of that. I think that's going to lead to application of the exclusionary rule in a criminal case.
But now we're back to my original question.
Okay.
And you seem to be saying, yeah, well, that's the criminal offense, and we can take someone into custody, form reasonable grounds later, as long as it's a civil matter. Is that what you're saying? And my question earlier is, how does that comport with the language that says the custody, taking into custody, has to relate to the offense? Not the civil investigation, but to the offense, which is the criminal offense. And what I'm getting at is, if that's the case, why doesn't the officer have to comport with the requirements for taking someone into custody for the criminal offense? In other words, have probable cause to take him into custody, even though we may have a civil case emanating out of this later. The statute doesn't tell us that officer can take custody for the civil investigation? Am I going in circles for you, or do you understand what I'm asking?
Well, in a way, I'm trying to think of how to answer that. The statute doesn't sets out arrest or otherwise in custody. Otherwise in custody has to mean something. If it means the same thing as arrest, it's just redundant. It's unnecessary.
And I'm not there. I'm not splitting the hair between arrest and custody. I'm going to later in the sentence where both of them, or at least the otherwise in custody, at least that part relates to any offense that has to do with driving, alcohol-related driving offense, which relates to the criminal charge. And so there's no place in there that you can shoehorn a custody for civil investigation that I can see.
Well, I don't think the officer was intending to do this, or his idea was to do a civil investigation. He was taking part in a DUI arrest. He didn't have video equipment with him, so he placed the person under arrest, placed Sloop under arrest, and then took him down and did further testing. Now, the thing about it is, I don't think the court ought to consider what the court's perception is of his subjective idea about further investigation. There's a Supreme Court decision, Hoffa versus United States, that talked about the fact that an officer is not required to end an investigation at the exact point that he thinks he's achieved probable cause, that he can continue to investigate. So I don't think looking at the officer's idea or what the court may think was his thinking, he expressed what he was doing. He would have done field sobriety tests there probably if he'd had video in his vehicle, but he didn't. Officers commonly use videotape of field sobriety tests to provide evidence in the DUI case, not just for probable cause or reasonable grounds.
Mr. Keller, assuming an objective standard, as you've asserted, can you just list for me what the factors are that pointed to the existence of probable cause at the time the cuffs were put on this gentleman?
Sure.
Thank you.
The initial observation the officer made when he was stopped at an intersection, Mr. Sloop had the left-hand turn signal and sort of started and then hesitated at the time of night. It was a little bit after midnight. That, I think, plays into it. What he described was that as Mr. Sloop went in front of him in this well-lighted intersection where he could see him well, as he sort of draped over the steering wheel as he drove, and he thought that was unusual. He testified in the district court that those are both things that, according to his training, are indicators that a person may be under the influence of alcohol. At that intersection, the officer wasn't intending to follow him until he saw that. He was planning on going through the intersection. They were going in opposite directions. But as soon as he saw the hesitation and the manner in which he was seated in the vehicle, he thought it may be worthwhile to follow him. He followed him, didn't see any driving behavior or that sort of thing, saw the tag light was not eliminated. That was grounds for a stop. That's a traffic offense, a traffic infraction. That's something he can stop him for.
But it doesn't add anything to your analysis of whether there was reasonable.
As far as the tag light, nothing.
It doesn't add to the reasonable grounds analysis.
No.
It
But
also
there
wouldn't
were
have
grounds
been-
for the stop.
And it also wouldn't have been an independent grounds for arrest,
The tag light?
the tag light.
No. I don't think you arrest for traffic
I think we have to
infractions.
consider that when we look at whether or not there was a valid custody.
No, I don't. I don't think we would contend the tag light would be a reason to arrest. But anyway, the driving behavior, I think, is something that factors into the reasonable grounds because the officer testified with his training. Those are things that that may indicate a person's under the influence of alcohol. Then he stopped the vehicle, and he was right. First thing he notices when he contacts Mr. Sloop is what he characterized as a strong odor of alcohol coming from the vehicle. Mr. Sloop had a passenger. He said there was an odor of alcohol with him also, but after he got Mr. Sloop out of the vehicle, he could still smell that same strong odor of alcohol coming from him after he was outside of the vehicle. When he first talked to him, he noticed that he had watery, bloodshot eyes. That's another indicator that he testified to. He asked Mr. Sloop if he had been drinking, and Mr. Sloop said, not really. And he said, well, what do you mean by not really? And he said, well, I had one beer earlier at a friend's. Now, the officer isn't required to believe that he had just one beer. The significance of that is he's admitted consumption. That's what he's done. He doesn't, there's a lot of responses that officers get. I haven't been drinking, I haven't had anything, and they can smell the odor. I've had one, I've had a few. The Campbell case we've cited was a Court of Appeals decision that had to do with reasonable grounds to request testing. Actually, it was in the context of probable cause, but I think they were really talking about reasonable grounds. They just used the terminology in that case as to that. And set out, of course, that the standard is that the officer has to have sufficient evidence to make a reasonably prudent officer believe that it's more than a mere possibility that the person is operating under the influence.
I know that language is out there, but we also have said that probable cause and reasonable grounds are roughly equivalent.
Yes.
Which is right.
Well, I think in
They're
Campbell
different.
they said that was a definition of probable cause.
That's the Court of Appeals. Do you
Yes,
have
it is.
anything
Yes.
to tell us what we've said about it?
I know that Campbell has been cited in some of your decisions.
For that proposition?
Yes. I think, I'm trying to think, I think perhaps Allen. There was a case, now that was a different issue. I think Allen versus Kansas Department of Revenue, I believe.
Your
One, but there may be some others. I don't know.
opposing counsel has argued today, and you heard him argue, that the two are equivalents. Reasonable grounds is the same thing as probable cause. Would you agree or disagree with that?
I think the standard is the same. What he's arguing is that reasonable grounds has to be present at the time of arrest. I disagree with that. Reasonable grounds has never really been tied to the arrest. In fact, it's not defined in the statutes. The definition came from the case of, sorry, I just had a complete lapse here. Angle versus Kansas Department of Revenue. I think it was it was in the 1980s. And Campbell decided that the standard for reasonable grounds had to be the same as probable cause. And part of the reason that they decided that was because they reasoned that you can have a test request, you can have a test done without there having been any arrest at all. Because if there's an accident, you can request a test. And there has to be reasonable grounds, the statute said in that instance. And they said, well, in order to comport with constitutional requirements, we're going to say that reasonable grounds means the same standard as probable cause. But they didn't tie it to an arrest because the reason they arrived at that standard was because a test can be done without an arrest. And then that's what counselor said too.
How does that work into the facts of this case where we don't have an accident, we don't have a driver of a motor vehicle, or of a common carrier, we're looking at an arrest or custody? Don't you have to have probable cause to, in this case, under these facts?
The statute merely, there's a question. I know there are some other states that have looked at that issue and said the determination of an arrest is an issue of fact. In other words, just was the person arrested, not whether it was a valid arrest. And I don't know that that's ever really been resolved in Kansas. In this case, I think the grounds were met for probable cause. If you go, well, I've gone through those factors in this case.
Before you proceed along that line, that was a question I had. Are you done listing all the factors that you believe could be relied upon to determine whether reasonable grounds or probable cause existed at the time the handcuffs were put on? Do you have any more to add?
I think the driving behavior the officer saw, one, the strong odor of alcohol that he smelled in the car and outside.
Excuse me, counsel. The last one I have that you told us was the driver admitted he'd had one beer.
Yeah, the admitted consumption.
Was there anything after that?
I don't believe so at that point. The rest was done later. Right. Those are virtually the same things that were in the Campbell case. Campbell, there was speeding in the early morning, 72 and a 55. Odor of alcohol wasn't characterized as strong or anything. Glazed, bloodshot eyes, and Campbell said that he had had a few drinks. And the court said that's more than sufficient to meet that standard. It started
with a speeding, a moving violation.
I'm sorry?
It started with a speeding, a moving violation.
Yeah, and I think what I would argue with regard to that is I think the driving behavior in this case was maybe more indicative of being under the influence than simply speeding would have been. There isn't any. In fact, I've actually
wasn't enough to pull him over though.
No, I agree. Just as weaving in a lane, isn't a traffic offense either, and that sort of thing, and that may be indicative of a person that's under the influence.
I'm sorry. The officer then followed him for quite a distance after he saw the leaning over at the traffic light and didn't observe any traffic violations. Does that can that negate that factor?
I don't think it negates it. I think it should be considered.
So should we just look at everything that supports probable or reasonable grounds and nothing that would detract from that?
Well, the thing about a person that's intoxicated is they don't do everything wrong.
Right.
State versus Morning, a decision we've cited in our brief that was the decision of this court. They made the point that a person who's under the influence may drive in a perfectly straight line down the road and then not be able to handle whatever traffic situations develop at that point.
I do understand that. I just think you do have to look at the totality of the circumstances. You can't totally discount the fact that there's no traffic violations either.
Yeah, I think the court has to look at the totality of the circumstances. My understanding of that term is you don't take each thing and look at an innocent reason for that and discount it, and then takes the next thing and discount it for some innocent explanation. But I think it's important, though, that
there could also be an innocent explanation, though, for his slight hesitation at the. I'm just saying, it's all sort of nebulous in terms of.
I've been doing this a long time. I've heard innocent explanations about everything. I haven't been drinking. Somebody spilled alcohol on me. My eyes are always bloodshot. You don't know, officer, how his speech always sounds when the officer hears that it's slurred. There are innocent explanations for practically every factor.
Is there any reason to think that if we didn't have the slumped over, or not the slight hesitation and a little bit of slumping over the steering wheel, let's say we didn't have that. All we had is the bloodshot eyes, the smell of alcohol, and the admission of one beer. I understand, but
this is
is that enough?
This is a really close case. The district court said that in looking at the standards and looking at what happened in Campbell. It's difficult to start pulling things away and say, is this enough? Is this enough? And that's a difficult path to go down. The facts are, in this case, the officer observed that, and according to his training, those are indicators.
And if you go under subsection A1, if you're not in the blood alcohol level, the definition of the crime is under the influence to the point where the driver is incapable of safely operating the vehicle. And so when you're looking at the totality of the circumstances, the ability to safely operate the vehicle while being followed has to factor in.
Yeah.
And I think that's what Justice Moritz was trying to get you to accept, is that there were mitigating or contradictory observations that can't be ignored if you're looking at the totality of the circumstances.
I suppose, well, like I've said, there are, NHTSA has a manual for officers that has probably 80 or 100 different things they're going to observe. In any given case, they're not going to see most of those. So, I think the standard under the totality of the circumstances is that if there are sufficient factors to provide a reasonable officer, reasonably prudent officer, with enough evidence to believe it's more than a mere possibility. That's the standard. And it's not a matter of were there 5 things that the officer observed and 10 things the officer didn't. It's not a matter of looking at that. In every case, there are going to be more things.
I'd feel a little better if there was an officer here who understood or was suggesting that he had reasonable grounds at the time of the arrest. But this officer thought apparently he needed a little more. And so we're not looking at an officer who said with some certainty, yep, I've got reasonable grounds right now. We're kind of looking at this after the fact and trying to decide. But should we factor that in, that the officer himself seemed to feel more investigation post-arrest was necessary?
No. It's not a subjective standard.
It isn't subjective. I understand.
Cases have said that, just as a court may overturn an officer's decision when he thinks he has probable cause, they may find probable cause even though the officer thinks he doesn't have it. Mm-hmm. It's a matter of an objective standard.
Okay.
Counsel, sorry, were you done?
Yes.
To help me clarify what's going on here, I'd like to go back to the timeline of events that I discussed with opposing counsel. And the first event on the timeline would be when the officer first observed the defendant. Mm-hmm. And the last event on the timeline would be under 81001 when the officer said, I am now requesting you to take this test. Back at the station house, I want you to take the test. Mm-hmm. At what point on that line do you contend that the officer met whatever legal standard is necessary in order for him to later have requested the defendant take that test?
As we set out in our brief, based upon the Campbell decision and the striking similarity of factors in this case, we believe that that standard was met at the time that he put the handcuffs on him. Now, because reasonable grounds is not tied to the arrest, we believe the other things that happen later can be considered. He failed one field sobriety test. He had 2 clues. And the other one, he had a clue, but that's all. And that's not unusual on these kind of cases where the standard is .08 and, he wasn't falling down drunk.
And if we were to accept opposing counsel's argument that probable cause is the equivalent of reasonable grounds, if we disagree with your main contention in your brief, then we're done, aren't we?
Which main contention?
If you don't have probable cause to arrest, that means you did not have reasonable grounds, at the time of arrest, so anything that occurred before that just could not be considered.
Yeah, if you disagree with our proposition that reasonable grounds can consider things after the arrest, is that what you mean?
No, I'm saying if he says there's no probable cause for the arrest, and he also says that no probable cause means there's no reasonable grounds, and if we agree there was no reasonable grounds, no probable cause for the arrest, then we're done.
If you determine there's no reasonable grounds, yes.
No reasonable grounds at the time he was handcuffed.
If you determine that's the point in time at which reasonable grounds has to be determined, and you determine that the information that the officer had available to him at that point was insufficient, yes.
Yeah, well, inherent in my question is if we said there's no probable cause for an arrest and reasonable grounds is the equivalent for probable cause, how can we consider post-arrest evidence to search for reasonable grounds?
Well, the question is whether reasonable grounds has to be determined at the time of arrest or can be determined or is determined at the time of the test request. That's the issue. Now, if you decide that it has to be determined at the time of arrest and you decide there is not probable cause for arrest, I agree we're done. We disagree with that, obviously, but that would be the case. I think the reading of the statute, the counselor decision we're relying upon, where the court said, reading the same language in the statute that has been unchanged since the counselor decision was handed down, said that reasonable grounds can be determined before an arrest or after an arrest, or, as the Engle court also said when they defined what reasonable grounds was, without any arrest whatsoever.
All right. Thank you, counsel. Do we have, I think I cut somebody off over here. You had a question. Any further questions of counsel? I'm sorry.
Well, I get everybody's expecting one, we'll give one. No, would you say then that if we agree that reasonable grounds does not have to be established until they give the advisories, that in this case we have to determine if the legal question that you said that has been unanswered as to whether or not an arrest has to be valid?
Something I've wondered about sometimes is what the real meaning of otherwise in custody is. What that means. Why did they put that wording in there? They say under arrest or otherwise in custody. And that has been defined in some cases as being broader than just arrest. So I don't know. Maybe it is an invalid arrest. I don't know. I mean, I'm not sure what that means. Obviously, before the test is done, something, grounds like probable cause have to be, that standard has to be achieved. That's what Engle said in the reasonable grounds to request the test. But the other issue that comes in is the use of the exclusionary rule in this type of proceeding. If there was an arrest without probable cause. Because, a lot of those cases that dealt with Martin had to do with stops that were invalid that then led to an arrest. And the argument is that the arrest isn't valid because the stop wasn't valid, therefore the exclusionary rule ought to apply. I know when I briefed that case that we had a lot of cases that had to do with whether the exclusionary rule should apply when the arrest was improper. And those were included in our brief with regard to that. Now, the facts in Martin didn't have to do with that specific question and had to do with the stop. But that was the analysis. The stop's invalid, therefore the arrest is invalid, therefore you can't take my license away. And the court said the exclusionary rule doesn't apply in this type of proceeding. And I think we still got that question here. If the arrest wasn't valid, then do we exclude that evidence that that was achieved after the arrest. Our argument is that you can't by tying all those together.
You mentioned earlier what's the purpose of otherwise in custody if it doesn't mean something other than arrest. Well, I would ask you, what's the purpose of requiring that an arrest or otherwise in custody for an offense? Why require that if we're not going to enforce it? That if set up conditions for authority to request, but say if they don't meet the conditions, it doesn't matter. I mean, what's the point? Doesn't that render those conditions superfluous if there's no sanction for failure to meet the conditions?
Well, certainly, as you're well aware, in DUI cases, if there's not an arrest, they're going to exclude the breath test, and that's not going to be considered in the DUI case. I mean, there is that impact.
But we're talking about the conditions to request the testing that then will move to subsection 1002, that will move to 1020. So you're saying those conditions were only intended for the criminal offense and not for the other driver's license provisions that you described as closely intertwined?
I'm not really sure. The case that stands out to me about the otherwise in custody was the State versus Lewis case, and I think I may have talked about it in my brief, and I'm not sure that I did. That was a case that occurred before the notices were required by statute to be provided. And it was also before language was in the statute allowing a test to be done if there was an accident. And what happened was Lewis was involved in this horrendous accident. He was taken to the hospital, and a nurse came in to take a blood test. And he wasn't under arrest, and everybody agreed he wasn't under arrest. And at that time, that really, you had to be under arrest or otherwise in custody. That was the language. There wasn't anything about accident. And so everybody agreed he wasn't under arrest, and the question became, well, then, was he otherwise in custody? And the Supreme Court determined that he was otherwise in custody because the nurse told him, we're taking this test for police purposes. And that was enough. And there wasn't any officer that put handcuffs on him, that restrained him. They were out in the hallway. And that was it. And they said, well, that's otherwise in custody. No arrest. And no accident. I mean, there was an accident, but the statute didn't allow for testing based upon an accident at that time. So that was the ground for it, otherwise in custody. I don't know. Arguably, I guess there was probable cause, and I think the case may have talked about that, although there was not, in fact, an arrest that took place. So I'm not sure. But I do think the application of the exclusionary rule in this civil proceeding done for the protection of the driving public is an important factor to tie into this thing. I know I'm way over my time, but if there are any other questions.
Any more questions of counsel? I will not look expectantly this time.
I'm not going to look.
Thank you.
Thank you, counsel. You reserve 3 minutes for rebuttal.
Thank you, Your Honor. Briefly.
Mr. Shepard,
Yes.
I'm trying to understand your position. Are you saying that in order to rule in your favor today, the court need look no farther than what was available to the officer at the time the cuffs were put onto your client?
Yes. And
then you get a ruling in your favor, or do we need to overrule Martin to get a ruling in your favor?
No, you don't need to overrule Martin at all,
Okay.
because KSA 8-1001 subsection B still requires there to be an arrest, and you don't have to overrule Martin. There, they wanted, in Martin, it restricted it to what was in the statute. And here, the arrest is right smack dab in the statute. It's not in the statute about the stop. So we have statutory basis.
And the department hasn't previously made an argument in this case that this somehow falls under that otherwise in custody portion of the statute. They've admitted there was an arrest at the time the cuffs went on.
Correct.
Okay, I understand it. Thank you.
Thank you. And I want to just respond to what Justice Moore had said, and I think also Chief Justice Lawton said with the equating the probable cause standards to reasonable grounds. In Allen, starting at page 656 and going through 657, squarely the case equates probable cause and reasonable grounds. But I'll read what they talk about. The totality of the circumstances. Probable cause is determined by evaluating the totality of the circumstances, and they cite Skate v. Hill. As in other totality of the circumstances tests, there is no rigid application of factors, and courts should not merely count the facts or factors that support one side of the determination or the other. State v. McGinnis and also Smith versus Kansas Department of Revenue are cited. And what I caution and what I'm asking the court to decide is not to weigh just what the department is asking you to consider. The eyes, the smell, and the one beer, and this maybe when he was with the position of the driver. The department is asking for the court to consider Campbell. Campbell is not applicable. Campbell, read closely, only deals with whether or not there was probable cause to ask for them to do standardized field sobriety tests. It had nothing to do with them to ask for a breath test. And in that case, there was standardized field sobriety tests done at the scene. Not applicable here because they were done here at the station. Second, counselor is not applicable because there was an arrest for reckless driving. Here, there was just an arrest because he suspected of DUI and then arrested him for further investigation. That's not valid. Any other questions?
Do you have any further questions, counsel? Thank you, counsel.
Thank you.
Both for your arguments this morning. Court will take this matter under advisement.
Thank you.
At this time, the court is in recess for 15 minutes.